Number 24, People versus Simon Obi, 23133 FH.
Namesh Ganatra, First Assistant Prosecuting Attorney for the People.
And good morning, Your Honor. Breach Davis, B76203, appearing with Simon Obi, who is present and appearing via Zoom in custody. Mr. Obi, will you state your name for the record?
Simon Obi Jr.
I'm Mr. Obi, and good morning, Mr. Davis. I'll let you go ahead with your bond motion.
Yes, Your Honor. This is our motion to reinstate my client's original bond. No, the court had an opportunity to review the arguments that I laid out in our motion. I would like to point out that my client, he didn't miss his court dates, as the prosecutor said. He was late for his court appearances. He did show up to those court appearances. He had a transportation issue. He had originally made arrangements with a friend who was supposed to take him to court. His friend didn't show, so he had to take public transportation to his court date. And he did, in fact, turn himself in after the warrant was issued. Now, I've been in communication with his parents pretty much on a weekly basis. They've assured me that transportation will no longer be an issue. They'll make sure that he attends all of his court dates. And I know he missed some ETGs while he was out on bond. So I think the way that we can solve that issue is for him to have a tether device, tether on his ankle. That way the court will know if he's using the alcohol. So he has retained counsel at this point. He's fully invested. He's going to appear at all of his court appearances. It's not a flight risk at all. He's here. He's local. He's in Michigan. He plans on attending Baker Community College. So I would just ask the court to reinstate his original bond. I think it's appropriate.
Thank you, Mr. Davis. Mr. Ganatra.
Yeah, I know the people would rest on their written response. Thank you.
I don't have a written response.
Wait a minute. Your Honor, Ms. Anderi had a response dated June 14th of this year that she forwarded to me, and she said it was submitted via email.
Well, sum it up for me, Mr. Ganatra. It's not in the court file.
That's fine. Just one moment. Counsel, Mr.
Yeah.
Davis, do you have a copy of the response?
I believe it was emailed to me.
Okay. People admit the defendant is charged with home invasion. People admit in part and deny in part on two that the magistrate issued a 5,000 PR bond and placed the defendant on GPS tether. Victim's home is exclusion. There was also a community corrections order for standard supervision drug testing. And three, the people deny the claim in the defense motion that his bond was revoked based on missing 6 ETG tests. That's incorrect. On December 1st, 2022, the defendant failed to appear for a probable cause conference at 14A District Court. A bench warrant was issued for his arrest with the 10,000 cash surety bond. On December 21st, 2022, after a warrant recall request was sent to the district court, the warrant was recalled and a 10,000 PR bond was issued. After another few court hearings, the matter is set for preliminary exam on February 21st, 2023. The defendant failed to appear for court again. The people's witnesses were present and ready to proceed at the examination. The court issued another 10,000 cash surety warrant. During the time period of November 18th, 2022 to February 15th, 2023, the defendant did not complete any drug tests, missing a total of 7 drug tests. On February 24th, 2023, the defendant appeared in custody before Judge Karen Valvo in the 15th District Court. At that time, due to his failures to appear, his bond was revoked and he was remanded until his preliminary examination on March 14th, 2023. The prelim was held on March 14th, 2023. Witnesses testified, including the victim, Amanda Ward, who identified the defendant as one of the individuals who broke into her house in the middle of the night and held her and her children at gunpoint. That's preliminary exam transcript pages 7 to 9. At the conclusion of the examination, Judge Burke found probable cause existed for the matter to be bound over to circuit court. Additionally, the court addressed the bond at the conclusion of testimony. Judge Burke set the bond at 200,000 cash surety, referencing preliminary examination transcript page 32. Judge Burke stated his reasoning. That's referenced specifically on page 31 of the preliminary examination transcript. I'm not going to read all of that to you. The Michigan court rule allows the court, after arraignment, on the information to make a de novo determination and modify a prior release decision or reopen a prior custody hearing. People object to any reduction in bond on this matter. Judge Burke heard the testimony at the preliminary examination and factored in the defendant's 2 prior failures to appear in his decision to set bond. Defendant poses a risk to the safety of the victims and community. And he's also failed to appear 2 times for court on this case. Additionally, defendant was on bond for 2 counts of CCW in Wayne County at time of this offense, as well as on probation to the 18th District Court in absconder status, according to the police report. This further shows a blatant disregard for the court's conditional bond and probationary orders. Also in Wayne County, from a few weeks before his arraignment on this home invasion case, the defendant was charged with possession of narcotic cocaine, less than 25 grams, and assaulting, resisting a police officer with a offense date of October 24th, 2022. This also would have occurred while the defendant was on bond for 2 counts of CCW in Wayne County and on probation out of the 18th District Court. Defendant's sentencing guidelines are approximately 51 to 84 months MDOC. Based on all these factors, people request that the court deny the reduction.
Mr. Davis, any response to that?
It's just a written motion. I laid out my argument.
Okay. Taking a consideration in the testimony that was given at the preliminary exam, the increase of bond after hearing the testimony, the fact that there was bind over, I can't disagree that there is definitely a concern that the court has for public safety here. But concern is slightly compounded that we're going to see Mr. Obi back because he was, as stated by Mr. Granatra, on bond for 2 CCW charges and had absconded recently from the 18th District Court. And then we did have the one missing here in the late response and then the lack of testing. Mr. Obi hasn't demonstrated that he can follow court orders from the beginning of this case going forward. But also there's a historical aspect of looking at it from absconding from probation and being on bond for other offenses and picking up this new one where there has been at least a probable cause hearing at this time. Should I find additional information, I would make a different consideration maybe after the motion to quash is heard and I have the response from the people, but at this time motion for bond reduction is going to be denied.
May I talk to you, ma'am?
Mr.
Davis, your client's wanting to talk.
No, not at this time, Mr. Obi. Can I have a breakout room with him for a second?
No, he's in the jail, so we don't have that ability to do that during the docket, unfortunately.
All right, we're set for our motion hearing.
I think we're up next. No, we're up for a motion to quash hearing on Monday, the 24th at 10 a.m. at the request of in-person hearing.
Okay, and the court did receive my motion.
I do have yours, yes. I don't have a response yet from the people.
All right, thank you.
Okay, thank you.
Number 10, People versus Christopher Cacelli, 22417 FH.
Name is
Hi, Mr.
for the people.
Mike Gaddy, Assistant Public Defender, on behalf of Mr. Cacelli, Your Honor.
It looks like I have filed here a case report.
Oh.
That came in on June 14th that I did not see. It is a request that the following violations be added. Mr. Gaddy, do you have a copy of it?
Yes, Your Honor, I did receive those.
And did you have the opportunity to go over those with Mr. Cacelli, the additional?
Yes, I believe Ms. Noveski did last time we were in court.
Okay. Because they're new, I'm going to arraign him and just let him know. Mr. Cacelli, you already have a violation of probation pending that had 15 counts of violations on it. The probation department filed an amended violation, and it alleges the following: that you had a confirmed alcohol consumption starting at 7:22 p.m. on 1/28/23 until 2:06 p.m. with a peak alcohol content of 0.437. It further alleges that you had a confirmed tamper starting at 7:18 p.m. on 1/31 and ended at 1:20 a.m. on 2/1 with a total duration of 6 hours and 2 minutes. Alcohol was detected during the tamper. The tamper was also confirmed at 7:53 a.m. on 2/1, ending at 10:55 a.m. on 2/1 with a total duration of 3 hours and 2 minutes, and alcohol was alleged to have been detected during that tamper as well. As previously stated, you're entitled to have a hearing to contest these allegations. Mr. Gaddy has already been assigned as your counsel to assist you with those. Is there any additional information, Mr. Gaddy, you would like me to put on the record for him?
No, Your Honor.
Okay,
We'd stand mute to those violations, Judge.
okay. All right, what are we doing today?
Your Honor, I'd ask to set those matters for hearing and move these matters that were already pending with them. Last time we were here, Mr. Kelly has now completed the Dawn Farms in jail program and is doing AA 1 day a week, which is on Saturdays, which is when they hold them. He's also a trustee, and I had thought that he had, and I had to do some digging to find out if he was assessed for that. How come he wasn't assessed for any potential release to treatment? And I did get an answer that they say that there's a new policy that court orders that anyone without a release date has to have a court order to be assessed for that, which it must be. Well, I think we had a fellow last week who went, but anyways, so either if Mr. Ganatra would not object to such an order, I can, and the court would allow screening, I can present an order. Otherwise, I can file a motion for that before the next hearing day.
I'd like to hear from probation.
I think probation has recommended MDOC on these charges, Judge.
That's correct.
Okay, Mr. Ganatra.
Mr. Gaddy had proposed putting together, Mike, can you tell me exactly what you're proposing on that?
Well, our social workers have met with Mr. Chikelli as well, and I don't think he's had any real inpatient substance abuse treatment in any time in the recent past. He has shown a willingness and some initiative to actually get into the Dawn Farms program and do the AA things. I'd ask that he at least be assessed and see what if any treatment that they might recommend for him before to see if we can make any kind of case for something other than MDOC treatment for him.
In probation, my understanding is the recommendation is 18 to 48 months.
That's correct.
Mike, how much time do you need?
I looked to, just for, it looks like, based on his last PSI, he had been referred to complete the Dawn Farms program on multiple occasions. DOC records indicate he's not successfully completed the Dawn Farm or any other program. I'm not sure if that's necessarily true in that statement. It reads a little awkward because it says also in the section just above it that he did complete Home and Vision in 2008. He did not complete Dawn Farm in 2020. And it looks like he went to CBI at some point, but no dates confirmed.
And that's, yeah. If we had, like I said, prison's going to always be there. If like I said, he has taken the initiative here. The Dawn Farm program, I thought that was an outpatient program. He failed in last time. But I don't know if so basically what I'm looking for is if we could set these new matters and the old matters out for a hearing, if the court would consider ordering an assessment, I can prepare that order and we can see if the assessment could get done and see if there's some alternate to prison should he be found guilty of the violations. I mean, looking at the underlying charges, I don't think they're theft charges. I don't think they're assaulted.
Mr. Ganatra?
I don't have a problem with that. I'll give them some time to see what they can come up with.
Okay, I'll write on the disposition. And when do you want to put this out to, Mr. Ganny?
Here, I don't know how long it would. I don't know how long it would take them to do an assessment. If we want to do a placekeeping for maybe the 17th or 24th of July.
All right, we'll go on the 17th. And I wrote on his disposition that we're looking for an assessment for residential.
Okay. I'm not familiar with how. Does everyone think the assessment would suffice, or should I prepare an order as well?
I don't know if the jail has a new policy. They certainly didn't inform the bench. So if they need an order, then probably best to do one of those.
All right, I'll prepare an order too, Judge.
Okay.